Welcome to Infringe at Your Own Risk.
Hello, everyone, and welcome back to Infringe at Your Own Risk with Rand Bateman. Rand is a registered patent attorney with decades of experience protecting patents, trademarks, and copyrights for clients from startups to international companies. My name's Sean O'Connor, and today Rand and I are talking about recent intellectual property cases and what those decisions mean for businesses, inventors, and brand owners. Hello, Rand. How are you?
I'm doing great. How are you doing, Sean?
I'm doing pretty well myself. As we speak, it's early morning for me, but that's happy to be up and at it. Talk about a recent intellectual property case, right? That you mentioned. What made it significant?
There's three recent cases that I think are really interesting. One of them is actually technically not an IP case, but it kind of relates to all litigation. So the first one is Cox Communications versus Sony Music Entertainment. So there are bad people out there who download copyrighted material and profit from it. And Sony has a very large catalog of music and whatnot. Cox Communication has 6 million subscribers, roughly, to their ISP services. And so over a 2-year period, the company that sends out DMCA takedown notices for Sony had sent over 150,000 notices to Cox about infringers. And Cox had a plan where they would first send you a warning if you're an infringer, and then they would suspend you for a little while, and then they would eventually terminate your service if you continued infringing people's copyrights. So Sony didn't think that was enough, and so they sued Cox for willful infringement of over 10,000 copyrighted works. Now, willful infringement elevates the damages that are given to the copyright holder. So that went to trial in a district court, and the district court ruled in favor of Sony and awarded $1 billion
Wow.
To Sony for the infringement by Cox's users. The Court of Appeals that heard the case affirmed the case, and then the Supreme Court considered the case and unanimously overturned the lower courts and ruled in Cox's favor that they were not liable to Sony. And in the copyright law, there's no per se vicarious liability for someone else has done, but the Supreme Court has recognized two. One is vicarious liability, such as an employer, right? So Sean, if you're working for a company and you go out and you copy a bunch of stuff and put it on their webpage, even though the employer himself didn't do it, the fact that you did it in your capacity working for the company, they can sue your employer for that.
My employer should have better supervised or been aware of my actions.
Exactly.
Right? Got it.
Yeah, and or shouldn't have told you to go out and rip off other people's stuff, which happens a lot. And when you get in litigation, when you get that letter or you get that email, don't buy a license, just go copy it from somewhere. It's getting harder to do that, but back in my early career when all of this stuff was developing, you would see emails like that. Yeah, we don't want to pay for a license, just go copy it.
Well, and so in this case, the Sony v. Cox, the Supreme Court was basically saying Cox was not responsible for their subscribers' misdeeds.
Right. So on Vicarious, they're not employees. There's not, and it doesn't have to be just an employee, but it has to be where someone's doing it and you're benefiting from it. So for example, if I hired you to do my website, right, and you put stuff on the website that's infringing, they can get me because I'm monetarily benefiting from your infringement, and I could have had some control over what you put on my website. So that's vicarious.
Yeah, Cox was not really getting any benefit whatsoever in that scenario. They're
Right.
just
Exactly.
providing the pipeline.
Yeah. So this whole case came down to contributory infringement. And under contributory, that's like you're encouraging people to infringe. Okay. And the Supreme Court looked at two cases. And ironically, the first case they looked at was Sony versus Universal Studios, where Sony was on the opposite side. If you remember, way back when you were a youngster, Sony got sued because they had these things where you put a cassette in a box and you could watch a movie. It was really cool. You know, these video cassette recorders that came out when I was young, and it was so cool. And then they started things like Blockbuster Video and all of that. Well, in that case, Universal had sued Sony, claiming that these video recorders were just infringement machines, because you could go on TV and you could record it. And the Supreme Court said, no, that's just time shifting. If you're gonna if a TV station's gonna play a movie, right, people should be able to record that and watch it later in case they have to work or they're going to be gone.
Sure.
And so they said, no, if it can be used for infringement, but it has non-infringing uses, then you're not liable unless you're encouraging the infringement. So that was in 1984, that was Sony versus Universal Studios. And they said the same thing here. Just because there are people using the ISP to infringe doesn't mean that Cox is encouraging them to infringe. And then they also looked at the Grokster case, and Grokster came out with downloading, file sharing software, and specifically kind of said, hey, this is really great for ripping off all this music, which isn't the smartest thing to say for your technology. They should have come out with a very business appropriate use of it, and then people will figure out how to use it for nefarious purposes. You don't have to tell them.
Yeah, always, right.
So cited those two and said, no, there has to be actual intent for the infringement. So if you're an ISP and you're not intending the infringement, then it's not there. So 7 of the justices ruled that and kind of went heavy on the intent. Justice Kagan the 2 of the justices said, no, we still believe our older interpretation's accurate, but on these facts, Cox didn't do anything wrong. So 9-0 decision. It's nice to see that from the Supreme Court. As an attorney, you hate 5-4s because it's just one judge away from changing when somebody else gets appointed. It's nice to have some solidity. So that's Cox Communications. How that's going to relate to other people is going to be interesting to see. I mean, that's for ISPs in particular, but AI platforms, other platforms where they're allowing users to upload stuff is going to be a little different because the platform is actually making the copy, right? Their website or whatever. So it'll be interesting to see how that pans out. But that's an interesting case. Might make it a little bit harder to sue people for infringement on some things. Second case is Fortress Iron versus Digger Specialties. And in that case, that's an inventorship case in patent law. So when you file a patent application, you're supposed to identify the inventors, who created this invention.
Right.
And nowadays you can file the application in the name of the company if they're obligated to assign it to somebody. But you still have to identify the inventors. It's a very strong requirement in patent law that they get credit. So what happened is Fortress Iron makes vertical cable railing panels that are used. And they developed these. They obtained 2 patents for them. And later they sued Digger Specialties for infringement. And in the process of the litigation, Digger figured out that Fortress had worked with a Chinese company as they were developing this product, and that a couple of people at the Chinese company had given valuable insights and modifications that could be made to make these panels work. Well, Digger said, well, wait a minute, you haven't identified all the inventors. And there is a procedure that you can go through in patent law where you can have a hearing to correct the inventorship, right? So usually leaving an inventor off if it's done non-intentionally is not that big of a deal. The challenge in this case was the two Chinese inventors had left that company and no one knows where they went.
Oh.
And so to have the hearing, you have to notify all parties that are affected by the inventorship change. Well, adding these people on would clearly have an effect on them because they would become inventors on this patent, but nobody could find where they were. And so the district court said, well, I'm sorry, your patents are invalid because you can't notice the inventors, so we can have this hearing, and granted summary judgment in favor of Diggers, invalidating the two patents.
They've washed it out just because they couldn't update it. Like it was mostly valid, so to speak, but they're like, well, no, if you can't bring it up to date, the whole thing is invalid.
Right. And this is why it's important, one, to figure out who your inventors are. So patent attorneys ask probing questions. Was anybody else involved in this? Should they be named? So that's important. And document it and get those people's signatures while you can, because it's hard. Sometimes 2 years later, 3 years later, you go to file the documents for the inventor and he or she has died. They've moved somewhere. You don't know where they've gone. So that was an interesting case where, normally it's, we'll just correct it if there's a problem with inventorship. That's one of the reasons not to put it off, because it can bite you if they happen to disappear. The third case that's really interesting, it's not technically an IP case, but it affects all litigation and the things that keep attorneys up at night. So in United States versus Hepner, Bradley Hepner received a subpoena from a grand jury and found out that he was being investigated for wire fraud and a host of other criminal activities. Mr. Hepner decided that he would be helpful to his attorneys. And a client being helpful can be very scary to a lawyer, because sometimes they do things that aren't really helpful. They think they're helpful, but they're not. Excuse me. So Mr. Hepner decided, well, you know what I'm going to do? I'm going to delve into generative AI. I think he used Claude. And I'm going to run out and get all this information to help my attorneys with the case. So he spent a bunch of time on these generative AI models, I guess putting in facts and stuff about his case. Well, the prosecution found out about it, and they subpoenaed all of his communications with Claude. So if you write something like, is it fraud, wire fraud, to send a document that I know to be false, and this stuff. So I don't know what the exact ones were, but something like that. So they subpoenaed them, and his side, the defense counsel, said, well, no, you can't subpoena these because of attorney-client privilege. And the judge said, well, these aren't really attorney-client privilege because they're not between the attorney and the client, number one, which is what attorney-client is supposed to be. And attorney-client privilege, you have to keep it confidential, right? One of the things a client can do to waive their attorney-client privilege is say, my lawyer said, well, don't tell the other side what your lawyer said, right? Because once you've done that, it's no longer privileged. You've waived that privilege. So, and in this case, he used a platform that right in it says, hey, we use this information however we want to. Yeah. So it's not confidential. And this is one of the things people need to be careful of. Using AI, attorneys included, it's not confidential in a lot of situations. And so you are disclosing things out there that could be discoverable and whatnot. Very careful. If you're going to use it, make sure you shield stuff so they can't trace it back to your client, right? Change the facts, use different names and whatnot. And then they also said, well, it's attorney work product. And they said, well, no, it's not a attorney work product because the attorney didn't ask Mr. Hepner to go do this. He did it on his own to be helpful. And so that didn't apply. And attorney work product, for those who don't know, It's kind of like attorney-client privilege, only it's to protect the thought process of the lawyer. So if I'm thinking about a case, I may write memos, here's our challenge in this, proving up this claim, or, here's weaknesses that we have. And, I'm putting those out to organize all of this for a case.
Yeah.
It takes months, sometimes years, to flesh out all of these issues and figure out what your support is. And that's protected from disclosure, but only if it's directed by the attorney and if it's confidential.
Yeah.
And if I go and do it on something that's public, then it's no longer confidential. So the court ruled that Mr. Hepner communications with the AI generation were public and therefore not protectable. He had to turn them over to the prosecution. So the reason that's relevant is I see now pro se litigants filing answers in cases that are clearly AI generated. And I have to admit, some of them were reasonably good. They weren't fleshed out like they should have been, but they were hitting the legal points that needed to be hit, jurisdiction, venue, other things like that. So, I mean, the day of AI is coming, but it's not here yet. Let me just throw in one last one, and I don't know the title of it, of the case, but there's been numerous.
You'll have to make it a little bit brief because we're coming up.
Okay, yeah, this is really short. So AI also hallucinates things, including cases. And a lot of lawyers have been caught. They run and have AI generate a brief for them, but the cases in the brief don't really exist. And so one lawyer recently got fined $30,000 by the court. And there's another one who I heard got tagged for over $100,000 for doing these AI. When an attorney signs, when they file something, they're signing saying, this is all legitimate case law. I've read it. I've looked at it. So AI is creating very interesting times in the legal community.
Yeah, well, and I know we'll talk about it more in the future, and I've had conversations with other attorneys. There's a whole industry now around helping law firms manage, some of these pitfalls. And, it's a significant new development in intellectual processes, law, all of it. So,
yeah,
as usual, Rand, great to talk to you.
Good talking to you.
I look forward to our next conversation.
Sounds good.
That's it for today's episode of Infringe at Your Own Risk. Staying aware of recent intellectual property decisions can help businesses adjust their strategy before problems arise. To connect with Rand and his team, visit the website batemanip.com. And don't forget to like, leave a review, and subscribe to the show so you don't miss any episodes. I'm Sean O'Connor. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.